appreciate you addressing settlement prospects because I think there is more and more appetite today for possible settlement on both parts.
A last wording on the de novo review, first of all, because I have mentioned the two safeguards
Yes.
for circumvening the waiver of the advance waiver of an annulment lawsuit. The Greek state is tempted to cloak, say, what it alleges to be, say, interpretative errors or errors in law of the arbitral tribunal, and under the mantle of public policy. You know, public policy has to be interpreted very narrowly. This argumentation is dismissed normally because it would lead to a review ad novo, which then would sacrifice all the advantages of an arbitral procedure, meaning speed, flexibility, confidentiality, etc. There is, however, there was a decision in the year, I think, 2022 of the Supreme Court of France, which confirmed the so-called Belocon decision, where money laundering was at stake, where the Court of Appeal, reviewing the whole issue, accepted that if here money laundering is at play or corruption, etc., that the Court of Appeal, investigating the enforceability or recognition of the enforceability of the decision, declaration of enforceability of the decision, its recognition, has the right also to take into consideration evidence which has not been provided before the arbitral tribunal and decide otherwise. This was an exceptional decision. A similar decision in year 2017 of the Supreme, 2017 of the Supreme Court of Greece has rejected such an argument. It remained on the basis that the reasoning and operating part of an arbitral award and the facts which led thereto are not subject to review. I know that Professor Kalavros has commended this decision by saying that the facts play here not a role, but only the implementation of the arbitral award, the operating part. If the operating part of the arbitral award as implemented is contrary to public policy, then an annulment ground exists. There are some opinions on that, but here I want to close this chapter.
Sure.
The other chapter is the enforcement chapter, where as you said, the states enjoy some privileges. So it is not possible to enforce a judgment, an arbitral award, and also a judgment, naturally, against the public property of the Greek state, property which serves public purposes directly. However, it has to serve them directly and not indirectly, meaning that it has to be absolutely necessary, this property, for serving directly the public purpose, like a school or a hospital or
airport.
Yeah. Or a ministerial building, etc. But this does not apply to assets which serve public interest, but only indirectly. For example, the Mercedes of our Prime Minister or something like that. This may, and also funds in banks and tax authorities may in general also be attached, because we do not know their sources. They are all serving public purposes, and one of the public interests to be served is the respected execution and enforcement of arbitral tribunals. So there you may also do something, if you find them, the money I mean. the issue of the settlement, okay, we have here, again, some privileges for the Greek state. You may apply to the Greek state for having an arbitral award settled, but this is subject to a positive legal opinion of the Legal Council of State. If the amount is big, the plenary session of the Legal Council of State, these are the lawyers of the Greek state, has to opine, and then the competent minister has to accept this legal opinion in order for the award to be settled. Sometimes the Greek state is willing to settle when it sees that an annulment lawsuit will have no chance to succeed at all, and then often it asks the concessionaire or the counterpart to waive the interest claim on the amount or to pay the amount in installments. And such kind of settlements have been achieved in the past.
Thank you.